Good morning. I'm probably talking to myself. It is somewhat early, but that's fine. So, a long time ago, I, let's see, I did a video about this gentleman right here, Luis Sanchez. I saw him because James Freeman shouted out Luis Sanchez. He shouted out specifically this video, ASD Docs video. This rather concerned looking gentleman in a backwards ball cap is ASD Docs. And ASD Docs is doing a critical review of this video. And James Freeman was very, oh, this confirms everything I ever thought about the judicial system. So I watched the video, and I went through it, and I was very critical of it. And people don't understand that I was being critical of the video. I wasn't necessarily saying that the facts are the way they are. I was saying that that the things that he purports to show in this particular video don't show what he alleges they show. One of the recurring questions I always got was about let's see if I can't make this bigger. Right here, there's a red clock, and everyone seems to think that that clock is actual clock that tells time. And I have seen these clocks specifically in I've only seen them in trial courtrooms for criminal matters. And I had occasion to ask other attorneys while I was in those various courtrooms what specifically those clocks were for, because I've never seen one actually tell the correct time. Most of the times when I see them, they are set on 000000, hours, minutes, seconds. And like the few times where they're not on that, they're not showing the correct time at all. But they do keep time, if that makes sense. Like, so you could, like, they're, as a second passes, the second digit updates. As a minute passes, the minute digit updates. So they keep time. And they're stopwatches. They're methods for specifically attorneys who have been given a specific amount of time to argue a point. That's how they know how much time they have, and how much time they have left is because of that clock that's pointing towards the attorneys, where the attorneys would be arguing. That's for them. So even if we could see, which is why I was saying, like, if we could see this, we would know how much time has passed, because it keeps time, but we wouldn't necessarily be able to say specifically based on the readout of this particular clock what time it actually was in the courtroom. So I did a skeptical look at his video, and then he did an update. And I don't have that specifically here. He did this update right here, where he went through and he answered questions that no one asked. And so I did an update video, and that is this tab instead. I did an update video where I went through the answers he gave, why they don't actually show what he purports them to show, and why it was completely inadequate to answer the questions. Now let me just give you my understanding of the background of this particular story. So Luis Fernando Sanchez was arrested for DUI. He was charged with driving under the influence. Apparently his blood test came back at like 1.12% blood alcohol content. And of course, the legal limit is somewhere around 1.08. So it's he was well over the legal limit. He wanted to challenge various aspects of the police process. That he wanted to suppress evidence based on a failure by the police to comply with certain elements of the process. He had a real problem with his attorney. This balding gentleman here was the main attorney, and this gal here was also assigned to the case. She had made appearances for Sanchez. A lot of times what they do is they'll have like a couple, like I've never been a public defender and I've never asked them exactly how they do it, but in going to these various hearings, a lot of times for the cattle call stuff, they'll have a public defender there who like who stands with the defendant first before they get assigned a public defender, or who will just kind of generally make the motion appearances. The kind of the public defender who's basically coordinating for the public defender's office, and they might have the specific public defenders who are assigned to a defendant there to stand with the defendant for that particular hearing. But that so she's kind of the one that kind of like runs everything, and she will stand with him if he needs it or whatever. And she apparently did stand with him at least once. But this gentleman was the attorney for Mr. Sanchez. So Mr. Sanchez had a fairly contentious relationship with them. One of the excerpts that Sanchez played was where this gentleman here, the attorney, recommended a specific course of action based on this attorney's understanding of the facts and the law. And Sanchez was like, "Well, can you send me over the case law so that I can review it?" And the attorney was like, "No, that's not my job, and no." And now I'm going to say the attorney did not handle it well, but I doubt the attorney knew he was being recorded by his client at that point. Talk about a breach of the attorney-client privilege, and possibly even a crime if Utah has, depending on their eavesdropping laws. However, I understand why the attorney would not do that, because we have seen, or at least I have seen, various instances where people like Chili have read cases and don't understand the holding of the case. And I've seen people like Dr. Law, who has told me he has a Juris Doctorate, and I have no reason to disbelieve him. But I see his attempts. I saw his attempts at analyzing cases, and he got them completely backwards. And you're going to be like, "Well, John, why are you correct, but Dr. Law was not correct?" And well, the reason why I'm correct and Dr. Law is incorrect is because every other attorney and has come to the same conclusion that I've come to. And when the case is cited in other appeals opinions or Supreme Court opinions, it comes to the same. They read the case the same way as I do, and not the way Dr. Law does. So, it's little things like that make you say, well, if I'm the attorney, look, we have to go. My job as an attorney is to figure out how to achieve the goals the client has set out. Not tactical goals, but strategic goals. The client gets to chart the strategic course of the litigation, whatever the litigation is. So if the client wants to go to trial and through trial for a criminal matter, then that's the client's decision. The client doesn't have to accept any settlement offer, regardless of how silly it is in the attorney's eyes. The attorney can make a recommendation. He could even argue for that recommendation. But it's the client's ultimate responsibility to determine where the litigation is going. It's the attorney's role. It's the attorney's job to figure out how to get there. The attorney gets to make the decisions on what tactical decisions to make, including what case law to use and to try to apply to the facts. And giving someone like Luis Sanchez the case law is again not going to be very helpful, because a lot of this is going to be like a factual analysis. So that's kind of the trajectory of where all this was going. And then one day, what we know is that Luis Sanchez was not there when the defense attorneys called the case. Now, in a cattle call environment, usually what happens is you're set for a specific time, but the judge is just sitting there waiting for the attorneys to kind of figure stuff out and get it going, because normally before each case is called, the prosecution and the defense are going to have to kind of meet and confer over like where are we at, where are you at, what do we do, do we continue this, do we set it for trial, where are we at, what's going on. And then when they have kind of met and conferred, then the defense counsel will get in line usually. And when he's called, he'll be like, Your Honor, I'm here representing so and so, and we're ready to proceed. And then the judge will call that case, and then both sides will make their appearances. They'll say what exactly it is they've kind of agreed to or not agreed to. The judge will make whatever orders the judge needs to make, and then the next defense attorney steps up. And the process repeats itself. It's just faster and more convenient to do it that way rather than for the judge to call each case when they may still be out in the hallway conferring or what have you. So what we know is that Sanchez, the defendant, was not there when his defense attorneys called his case. We don't know what time it was. We don't know what time he was supposed to be there. We don't know these things. So they called the case when their client wasn't there. Is that bad? Is that wrong? Well, it's certainly not a preferable thing. I think as a defense attorney, you would want to avoid that if you at all possibly could. But we don't know why they called it. I mean, this defense attorney here might have had another hearing he had to go to. He might have had another case he had to be at. He might have had other obligations or conflicts that are preventing him from staying late. It might have been late. We don't know. These are all speculations. All we know is that Sanchez's defense attorneys called the case before Sanchez was there. A warrant was issued for Sanchez. They recalled his bond, and they issued a $15K warrant. So Sanchez shows up at some time later. We know a defense attorney said that he saw Sanchez at 9:38. We know that the warrant was issued sometime after 9 o'clock. And so Sanchez was arrested on that warrant. He eventually had to pay. It was a cash only. So he alleges that he had to borrow the money to bond himself out. I'm surprised that he couldn't get I don't know Utah anyway. So anyway, he ends up getting bonded out. He has another attorney. He is given a new defense attorney. I can understand why he would have been given a new defense attorney. And the judge also recused herself from this case after he put the video up on the internet, and then at some point later she retired. So a new defense attorney and a new judge did a motion to suppress evidence. That motion was denied. They appealed that motion to suppress evidence, and the appeal was denied. So he pled guilty, and there you go, off to the races. So he decides to sue. And what we know about him suing is that he hired a law firm. I covered all of this in previous videos. So in this video, I think it's this video right here. I think it's the update, the skeptical look. I might have looked at the no, it was in the original video. It was in this video right here. Yeah, in this video right here, a skeptical look at the edited video of Fernando Sanchez. I covered a very specific issue that Fernandez might have, and that very specific issue is that attorneys who are going to file lawsuits for damages, civil suits for damages, have essentially two ways of taking those lawsuits. One way is they could take it contingent, and another way is they could take it hourly. Those are the two basic ways you could take it. There's obviously some minor variations, but roll with me on this. an attorney can make a lot more money on contingency. Contingencies can range usually from about 25% on a very low end to about 50% on a not unreasonably high end. So imagine, if you will, a recovery of $1 million where the attorney gets half of that. That's $500,000. For $500,000 for, generally speaking, about 2 years of practicing law to try to get that achievement, that accomplishment, that return. That's not terrible. That's not a terrible return on your investment. So you can do very well with contingencies. And what an attorney looks at in determining whether or not he's going to go contingency or hourly is a risk kind of reward sort of analysis, where he looks at the risk versus the reward, and he has to weigh those two things against each other. And the riskier that recovery is, the less likely he's going to go contingency, and the more likely he's going to say, sure, I'll do it, but I'll do it on hourly. So, and this is not directed at Luis Sanchez's case. This is just attorneys in general. This is my practice. This is every practice I've been associated with. This is how attorneys make money. This is our job. Like, we have to be able to assess the risk and figure out whether or not we're going to go contingency or hourly. If there is going to be a problem actually proving your case, if there is an issue with actual liability, with actually getting a judgment, that's going to be one of the things that we look at. How likely are we going to be able to prove that they did a bad thing and that we should get compensated for it? The second issue that you're looking at is how much are we going to get compensated? So number one, can we prove they did the bad? Number two, how much is the judgment going to be? And then the third thing that we look at, which I don't always talk about, but it does come into play, is how likely are we going to be to recover that money, i.e. actually get it out of the pocket of the defendant and into our pocket. And so if you look at like a typical personal injury auto accident issue, normally there's going to be an insurance company on the other side. So from the insurance policy, basically the policy limits, you know that like the top end of what your recovery could be based on policy limits. You're going to say, well, why don't you sue over it? Because generally speaking, recovering money from people, from your average Joe Blow, isn't a very much a winning proposition. Somebody makes $60,000 a year. Let's say they even own a house, i.e. they have a mortgage payment, but they only have like maybe even $100,000 or even $200,000 in equity. Are you really going to go after them for it? Well, you'd have to foreclose the house. I mean, if you got the judgment, you got the abstract, you recorded the lien, in order to actually execute and get the money out of the house, you'd have to foreclose on the house, which means you have to pay off their first mortgage, and then you can execute a foreclosure. You have to pay off the first. You can't foreclose the house if people with prior claims on the house still have their mortgages in place, their liens in place. So, and then you got to think, well, all he has to do is pay a couple grand, file Chapter 7 bankruptcy. He's got a homeowner's exemption, and so I'm not going to get anything. So, like, all of that would be in vain. So, really, in a personal injury, the attorney's looking at the cap on the policy limits, and if policy limits is $15,000, the attorney's going to be thinking, okay, well, how much time am I willing to invest into this for a $15,000 recovery, of which I'm going to get, generally speaking, $5,000 to $7,000 roughly. How much time am I really willing to put into this for contingency? Because I mean, liability might be super clear, but I'm limited in my recovery for what I can actually recover. So I hope that makes sense. So Sanchez got an attorney initially. He had an attorney. I don't remember where in here I talked about it. I don't remember. It was, here we go. Teeter and Vu. It's this guy right here. So, whoop. Let's see if I can't backtrack this a little bit more. Michael Teeter. His name was Michael Teeter. Okay. Anyway, his whatever. I can't pull it. Let's see why I put that in there. There you go, Michael Teeter. So this guy was his attorney. This guy seems like he'd be a very competent attorney. I can only trust that he would be a quite capable attorney. I went through his background, and this guy looked at Sanchez's case and decided that, well, you know, I'll do it, but I'll do it on contingency, is what I'm guessing. Obviously, I can't really see anything. I do have this. This is the lawsuit that Sanchez filed, and it was initially filed by Michael Teeter, and Michael Teeter bounced out right quick. Notice the withdrawal right there. So on January 14th of 2021, he bounced. So he filed it in October, basically the end of October. So November, December, so 2.5 months, roughly 2.5 months, Michael Teeter was out. This is before there's really been anything been done. You've got, they served him, service was accepted, you had the answer filed, counsel appeared, and then they're out. So why are they out? Why are they out? Well, Sanchez, see down here, motion for more time to find counsel. He's looking to find a new attorney. And how hard is it to find a new attorney if you have a slam bang killer lawsuit? Here's a hint. It's not hard. I know everybody was everybody. That's a bit of a stretch. I know that a lot of people were very skeptical of my skeptical analysis of this particular case, because a couple other attorneys YouTube attorneys had looked at it, and they're like, oh my God, this is terrible. This is horrible. And apparently came to different conclusions than I did. And that's fine. But bear this in mind. Who's right? Bear this in mind. So why did he have a hard time finding an attorney? Why did he have to raise money to get an attorney? Well, I'm going to assume one of two things. Either Vu was contingency, got a read on the case and said, wait a minute, there's no recovery, I'm out. Or what I think is more likely, Teeter said, you know what, I will represent you, I will do all this work for you on an hourly basis. And then Sanchez ran out of money, because it is expensive to pay an attorney hourly to do a lawsuit, because it's a lot of hours. It's a lot of hours. And even, you know, there's just not a lot you could do. I had a case very recently with a citizens organization where, I mean, it was a bunch of fairly rich people, and I mean, I wasn't lead attorney, but we ran them out of cash hard. And it's just, you get a complex litigation, you get a lot of stuff going on, you get a bunch of discovery coming through, etc. I mean, it eats hours, and there's not a lot you can do about it. So why did he have such a hard time finding counsel? Well, you know, my best guess is that he had a hard time finding counsel because it wasn't a good case. Because actually, when money is on the line, when an attorney has to gamble with all of his hours against a recovery, then the calculus is a little bit different. And the attorney's not going to be back, oh, you've got a great case anymore. He's going to be back, well, I'll do it for hourly. I'm not going to do it on contingent. And that is the best piece of advice. This is free advice. If you go into an attorney's office and you think you've got a killer case, and you say, you know what, Mr. Attorney, I've got this killer case, I want you to represent me. Here it is. And he says, sure, I'll do it for hourly. he doesn't have to tell you anything else. You know right there that your odds of recovery, your odds of a good return, of a significant recovery, are somewhere in the slim range. If it was none, he probably wouldn't represent you. He probably would be too ethical to say, I will do it if there's a 0% chance of recovery. But you know, if he's not willing to do it on a contingency basis, that there is a problem with payment. There is a problem. He has observed a problem. So there you go. So I spoke about this this particular case, the grift being over, and let me see if I can find where this particular, or was it in here? Was it in here? I am looking for stuff, and I hope you forgive me for looking for stuff. But I want to point out where things were and how they were progressing. It's this level of preparation that has endeared everybody to me. They know they're going to get a quality stream out of me with no dead air time and with all sorts of, here we go. All right. So this is when I did this video. This was in August of 2021. When I did this video, homeboy had reached $940 out of a $7,000 goal. And I mean, there you go. The attorneys offered me $45,000 in exchange for my silence, but I refused the money. So $940 out of 70, or out of 7,000. Today, let's take a look at what he's at today. Here's this GoFundMe. Today, he's at $19,250 for his out of $19,700 goal. And 1 month ago, this gentleman parted with 10 of his hard-earned dollars for Luis Sanchez, because apparently the grift doesn't end. Last update on this was in December 9th of 2021. Part 2 has been released. December 9th, 2021. Part 2 has been released. This is his December 9th. No, this isn't it. Hold on a second. Hold on a second. Where was it? Here we go. This is his December 9th, 2021 video, right? GoFundMe, I have a very ambitious project in the works. So I guess he changed his GoFundMe here to an ambitious project that is in the works, in air quotes. I mean, it's not on his website or anything like that, but whatever. He has an ambitious project. So there we are, $19,250 dues that has essentially been built on the premise of he's going to sue his attorneys because they conspired against him. You got to remember, in the original video, the attorneys conspired against him. The prosecution was in on it. The bailiff was in on it. The judge was in on it. All these people were in on it. Oh, but what happened, sir? But what happened? Well, here's his complaint. We're going to go through it, and we're gonna skip all the less important stuff. So general allegations, I'm not going to worry too much about, because you can get all those from Sanchez's videos. These are basically the same. These are the same allegations that he made in the videos. You know what would be interesting would be if Teeter actually resigned as the attorney after he got back the full unedited video recording of the hearing and found out his client lied to him. Speaking of which, I had a case like that. I had a gal who wanted to sue the police. They'd come into her home and they'd arrest her, and it was the way she described it. It was a pretty horrific arrest. They dislocated her shoulder. She was not a big woman. She was not a young woman, and she very meek, mild, and demure. Just very, very sweet, pleasant lady to deal with. And then you know, we prepare this complaint, and we're getting all of our medical records and everything put together, and her medical records don't show this dislocated shoulder. And I was like, oh, that's not good. And finally we get the yeah, we're having a real hard time getting her getting the recordings from the police to review, because they had body cams and everything like that. We were having a real hard time getting that, and finally I was speaking to one of the gals at the police station. She's like, yeah, they're not going to give this to you because there's an ongoing criminal case against her based on, in part, on these particular recordings. And I was like, oh really? She didn't tell us about this. And so then I asked her, like who's your public defender? And she gives me the name, and I get the recording from the public defender, and literally nothing of what the client had told me was true. Literally, other than the fact that she had been arrested, like literally nothing was true. I was like, what do you expect me to do with this? Like, all this abuse, all these things that you say happened, you know, that you didn't do anything. Like, you spit on the man, you spit on him, like, and he didn't even react. Like, I don't even understand. Like, what do you expect me to do? I can't play this in front of a jury. Like, they're going to crucify you. They're like, I would lose my license if I filed a lawsuit for you based on this video. It was crazy. What did you expect to happen here? Like, it's great to make allegations, and this is what Chili's going to learn. It's easy to make allegations, but man, like, eventually you got to prove this stuff. And if the proof isn't like you're in your favor, then like all you've done is waste everybody's time. It's insane. So these are all the blah blah blahs, and then first cause of action: legal malpractice, negligence. So he's saying that they owed him a duty, that they failed to conform with the ordinary standards of professional competence. Basically, what they're saying. I guess I will go into this just a little bit. So Sanchez alleged that there is a video recording of him being taken in to the jail initially, where they gave him some sobriety tests. He alleges he passed them. Obviously, the officers allege he did not, and then they did the blood test, and it was like 1.12. So the police department has said that they destroyed those videos. They don't have those videos, and there is a case in. This is the case that they relied on: State versus Tiedemann. It's a Supreme Court of Utah case where the Supreme Court of Utah says basically there's kind of a sliding scale balancing test. The more prejudicial the lack of the evidence is to the defendant, the less kind of bad faith you need on the part of the prosecution to dismiss the case over it. The more bad faith, bad actor you have on the part of the prosecution, the less prejudicial it has to be to the defendant in order to dismiss the case. But you have to look, you're gonna have to balance that, you know, is the prosecution destroying evidence to get a conviction? Would the evidence have exonerated the defendant? You know, that's what we're looking at. And again, you know, I don't know anything about this. I don't know how Sanchez can say that he passed the test. I mean, it's not like he received a piece of paper with a grade on it, but he alleges that he passed the test, and he alleges that this videotape would exonerate him, even though or would he alleges that the videotape would eliminate probable cause, thus making the blood draw, which showed that he was well over the legal limit, suppressible, I guess, for lack of a better word. The second one is legal malpractice, breach of fiduciary duties. This is essentially where they called the case, and as a result, Sanchez was injured. Third one is abuse of process. Again, the abuse of process is essentially the same thing as the legal malpractice, breach of fiduciary duties. It's again about the getting the bench warrant. And then the fourth one, this is the doozy. This is the important one. This is the 1983 lawsuit. This is a conspiracy between the defense, the judge, and all these people. This is the conspiracy, and this is the thing that he really needed to prove, and he did not get it. So what happened? Well, they answered. The answer isn't really particularly interesting. Confirm, deny, confirm, deny. So Torrance filed the motion to suppress the blood alcohol test. The motion denied it. So like we did all the things. Admit that plaintiff asked Torrance to forward certain case law. Admit that Torrance declined to do so. Affirmatively allege on information and belief that plaintiff secretly recorded the telephone conversation, and such recording, if it exists, speaks for itself. Great. So, you know what? Oh, this is interesting. It appears to confirm the reference statement made. They affirmatively allege the record speaks for itself. The record is the official record, not the audio and video courtroom recordings. They say the record speaks for itself. Further reference in this document to the record of the March 2018 hearing refers to those recordings and not the edited version created by plaintiff and forwarded to defendants in this matter. Anyway, so the big deal. Oh, were you able to see that? You probably weren't. There we go. It was this. This was the. I will scroll down through it. This document I will make available on Discord if you want to read it. I'll make all these documents available on Discord if you want to read it. I had to pay the state of Utah $5 dues to get this, and so you are going to benefit from me paying $5 dues. It's that big time attorney money. It's that big time attorney money. Deny, 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 admit. Admit, deny. Deny the characterization. Admit the court appears to confirm the reference statement was made and affirmatively allege the record of it speaks for itself. Deny the remainder. Deny Chestnut failed to speak with Sanchez before appearing before the judge in this matter. Deny the remainder. So it looks like they're saying, yeah, we said these things, yeah, but not like you said. Not like you said. Deny that a warrant issued at 8:48 a.m. That's kind of weird. Deny and affirmatively. Oh, remember how I was saying that that some of these hearings started at 8:30 a.m.? Well, you probably don't remember that, but in the previous videos, I kept saying we don't know. He doesn't show us that it wasn't set for 8:30 a.m. And they allege that Torrance believed that it had been set to commence at 8:30 a.m. based on prior hearings conducted. Oh, maybe it was. Maybe it was set at 9, and maybe Torrance just messed up and thought it was set at 8:30. I don't know. That's an interesting way to phrase it. Admit Torrance spoke to Chestnut regarding calling plaintiff's criminal case at approximately 8:45. He spoke to Chestnut regarding calling the case, and plaintiff was not yet present. Mm-hmm. Boy, it'd be really great if I actually got the if anybody wants to spend a bunch of money and get me the recording, the unedited recording, that'd be swell. I would love to go through it. Anyway, that is the answer. So what happened? Well, the big thing that happened is that ooh, the attorneys filed a motion to dismiss or a summary judgment motion for summary judgment on the 1983 claim. The court has granted that. The court granted it. There's no basis for a conspiracy. That sucks. No basis for it. No basis for it. Anyway, so the court dismissed the or granted summary adjudication on the 1983 claim. That left the two malpractice claims and the abuse of process claim. And then let's see. And then this was filed. Hold on. This was filed on November 10th. It's filed on November 10th of 2021. So the case was settled on November of 2021. We know it was settled because they jointly moved to dismiss with prejudice and all claims which were made. So they dismissed all claims, and each party bear their own costs and attorney's fees. And it was signed by that was Fernando Sanchez. That was his signature. So how much was the settlement for? I don't know. Now I know a lot of people like to believe that if there's a settlement, that is some sort of an admission of guilt, and it is not. It was not my case. I wish it was my case. I would have loved to have been involved in that case or been profiting from that case. But it was a case that was hourly. It was hourly. But as to make it go away, this was not Friday, but the Friday before. The opposing party offered up to $80,000 in attorney's fees to repay the clients that I was helping represent for the expenditures of their attorney's fees. There was the lawsuit was not going to win. It was not going to win. And in fact, the lead attorney in the matter had prefaced the initial client interview and basically every subsequent interview with, look, this isn't a case where we can win. The best case scenario for this is that we cause them so much cost and we take up so much time that essentially they abandon their plans and do something else. They go away based on the cost of the litigation. But it turns out that that essentially the cost of the litigation was essentially a rounding error in their ultimate plans, and so they had plenty of money, and they were paying a very expensive law firm who devoted multiple attorneys and a whole bunch of hours into fighting this. But even then, even knowing that they would win, even having motions plural to dismiss already set, already on calendar, even with that, they gave $80,000 as go away money. Now, I count that as a win for the clients because the clients essentially got made whole after learning that they didn't have the funds to do what they wanted to do, and learning that opposing counsel had all the funds in the world from which to draw, and would have definitely run everybody out of money. So I count that as a win, but it wasn't a win. It was here's money to go away. We've done the math. It's just worth it to us to get you out of our hair. This is nuisance suit money. Go away. But ultimately, on November 10th, 2021, this case was dismissed. Now, the GoFundMe is still active, and the last court update, or the last update, was December 9th, 2021, and it doesn't say anything in here about the case having been settled. Isn't that weird? Isn't that weird? So Homeboy is a grifter, and his grift is ongoing. And I think I have been vindicated in pretty much everything I've said about this matter. So with that said, I'm not going to spend all the time in the world on this, because I do have some things to do, but I will spend some time on this. We have pants. Good morning, all you kids on 34th Street. How to get to 34th Street. Burby, don't worry, talking to yourself can be very therapeutic. I definitely need the therapy, I guess. Hey Pants, lurking. I don't know what that is. Afternoon. Hey there, Pants. What does this have to do with chili? Chili's not referenced in the title, bro. Show us your lower pantsless self in all your glory. No. Hey guys, hi Belinda. I am not wearing any pants. Good for you, brother. Hi, hands up if you're not wearing pants today. Morning from South Carolina. Hope it's a good day for you. Yep, it is a great day. Pants check. Don't have any. I can confirm I am indeed not on MERB. Well, that's your loss, or mine. I don't know. Maybe a little both. Maybe a little both. On the toilet, no pants. Okay. Timers. I never wear pants, but here in the UK, pants are underwear. What the hell is this about? Cut to chase, please. No. Fist bump. No pants this early. Hell yeah. Hands up, and then again, I'm wearing a dress. Nice. Well, I'm not wearing any of those either. Good luck. Fist bump. Hiya. That clock is just a stopwatch. It does not tell the actual time of day. Well, it could. It theoretically could tell the actual time of day, but I've never seen it do that. I mean, I'm not excluding that. I'm assuming that it could function as a normal clock. I've just never seen that happen. Hi, nobody is paying MERB to perseverate. I don't. You got me. I don't know what perseverate is. So. No, 0.08. No, 0.08. I thought I corrected it to 0.08. Yeah, 1.12%. Yeah, he was like called drunk. Okay, forget all that. We want to know why you have Prince and Dido in your suggested column. Because Prince is an amazing musician, number one, and I don't know why Dido. I've some of her stuff was all right, but she was so auto-tuned. MERB has troubles with math. I do. I'm not a math doctor. I'm a fascinating man. Okay, we found Nasty Neat's protege. What's really going on here, MERB? It was just a grift. It was just a grift that I had sniffed out 2 years ago, and I've been vindicated. I know in some cases the judge limits each side to a certain amount of time. I just guess that those were timers for that. Yeah, that's what it's for. That's what they're. Yeah, 1.12% would technically be embalmed. Well, I've seen higher. I've seen higher. If you're a habitual drunk, like if you're one of those people where you wake up and you have vodka to get going in the morning, and you buy vodka, the cheap vodka by the gallon, just to get you through the day. I've seen those. I think 1.3 something percent. I mean, you'd be dead before you hit 1%. 1.1. You'd be dead before you 1%? I don't think so. World drunk driving record is 0.778. Well, maybe my numbers are wrong. Maybe my numbers are wrong. But he was 1.12%. I don't know. That's why you shouldn't drink after you give the blood. You have less blood to dilute the alcohol and have a higher concentration. Yeah, I mean, obviously. A Finnish guy blew 1% roadside, but his level was a bit under 0.7% in a more accurate test. Actually, there are apparently a few recorded cases of people just barely over 1% blood alcohol level who survived. It's either the Polish man or the Bulgarian man. There's a well, what it's 0.1, whatever. I'm not math. I'm not a math guy. There's a reason there's a law school doctor law in Chile. Have obviously not attended any of them. There is a reason there is a law school doctor law in Chile. Have obviously not attended any of them. I don't necessarily disbelieve Dr. Law when he says he has a Juris Doctorate. I don't necessarily disbelieve him. I have no reason to disbelieve him. My favorite story was a friend of mine who blew up a beach ball at a party, and the next day we let the air out through a breathalyzer, and the ball blew 0.11. Yeah, the breathalyzers aren't the most accurate in the world. Yeah, and I bet they were hardened alcoholics for decades. That's pretty funny pants. That ball was drunk. That's why I limit myself to roughly a pint of vodka a day and argue with the dogs, but not the bitey ones. Instead of dogs, I have cat fights. Nice. My homemade 70% will defo have you doing that. I bet it tastes real clean. I do not like the taste of alcohol, but the higher the percent, the cleaner it usually tastes. The first 10 batches weren't great, but after I got the recipe down, yeah, it's pretty good. I have hit the limit of my still, and I need a reflux condenser to go higher. So basically, attorneys are just after everybody's money. Well, no, attorneys are businessmen. We are in the we do this for a living. That's like saying mechanics are just after everybody's money. Roofers are just after everybody's money. We're not some noble profession. We do this for a living. We do, like, doctors are just after everybody's money. No, we do this to get paid. Like, you're an idiot. My cock sounds far away. Well, get closer, snuggle in. I made the calculations for a still, and the guy got 90% from it. He built the still himself and just needed the correct proportions for the parts. A rusty barrel and a hose is not that good. Defendants are already down and out. Attorneys basically just go over and sit in their kitchens. So apparently Great Gazoo is talking about all defendants. All defendants are already down and out, and attorneys just go over and sit in their kitchens. Yeah, okay, dude, you got to figure it out. Why are you even here telling me this? I mean, if I'm an attorney, so I should know this, right? That I'm just sitting in my kitchen or something all day, every day, usually 10 hours to 12 hours a day. Yeah, I'm just sitting in my kitchen, not doing anything, not doing any actual work. Yeah, I've been using a cheap Chinese water still. It costs 30 quid, made out of stainless steel, and is quite small, holds like a gallon, and so I have to do multiple runs. shit in their kitchens. Yeah, you're a loser. It's designed for water. I should point out that in my country, it's legal to do this. I don't really care. Illegal here too. But actually sounds nice. Small batches for private use. Who cares? Because we don't snitch. I don't snitch. No, it's legal here as long as certain criteria are met. You don't need a license. Oh, you got a license for that? Yep, had trouble focusing because of cat interference. New Zealand is best place. You can do it as much as you want on a huge scale as long as you don't sell it, I think. Have you considered making novelty beer? For instance, a super weak spirit that tastes dumb as fuck and smells chewy. I'm not an expert on drinks, so wouldn't know how that works. Nope, but last year I did make a nice mead for my birthday. I make my own low alcoholic mead, 1.2%. For me, it is about taste. Murby, hut that like button. Please help Murby. 13-23-401 Tennessee Reners versus whatever. Free speech retaliation. They took my guns. Yeah, mead is nice, high in strengths. It's quite dry though. They offered him 45G and he turned it down. I smell bullshizzle. I mean, it's possible. It's possible they offered him 45 grand out of the gate. It's possible. I my so my understanding is that these folks were represented by a malpractice carrier. So they had malpractice insurance. The malpractice carrier hired an attorney, and the goal of the malpractice carrier is to settle the case. That's their goal. The malpractice carrier is dollars and cents. They're looking at their bottom line. They don't really care if the attorney did it or didn't do it. They don't care. It's a business function for the malpractice carrier. So would they make an offer, a 45 grand offer to make him go away? It is possible. I don't think it's particularly likely. Not out of the gate, because 45 grand, would that 45 grand could see you through trial theoretically. So I would be more comfortable with 75, 80 grand to get you through trial, but 45 grand could in theory get you through trial. So they might have just offered cost of litigation. But he settled, Luis settled when there was he had filed a pending motion to amend his complaint. So in August, he had filed a motion for leave to file an amended complaint, and that was set for hearing on November 19th. And hold on a second. You probably can't see this. Where am I at? Oh, we're going to do that. So on right here on August 23rd, 2021, Sanchez filed a motion for leave to file an amended complaint. I think he saw that there were problems coming. My guess is he saw there were problems coming with this complaint. It was set for hearing on November 19th, 2021, and they ended up settling on November 10th, 2021. So my guess is that there was trouble coming down the road, and he settled for a lower amount than 45 grand. That would be my guess. Normally, I would sue you, Merb, to ensure you stop looking into things, but it's nice days, so we're good. Well, good. Courts are corrupt. They don't work as he dictates they should work. Dang tyrants enforcing codes and statutes. I'm detecting a little bit of sarcasm there, so I'm going to say excellent sarcasm, sir. You should have spoken to a 20-year law scholar. Probably should. Let Chili file the lawsuit for her. I'm sure he would help. Oh, that's the gal who lied about everything, and the police body cam video completely exonerates the police and makes her look like a complete tool. Yeah, that was terrible. Merv for president 2028? Absolutely not. All politicians are terrible, and I don't want to be a politician. Lol. Criminals lie. Absolutely. Spitting is worse than hitting. Well, they didn't hit her, so yeah, she spit on them, and they didn't do anything, but they did have to take her down to cuff her, but like she was like, it was an active resisting situation. Like, I mean, it was just, if she wasn't combative and spitting, they probably wouldn't have arrested her. But once she spit on them, I was pretty much the end of it. They're like, you're under arrest, by the way. And she was not very cooperative. Frauditors lie. Non-frauditors lie too. So there you go. Shelley has no intention of proving things. It's all part of his grift, probably. But Merb, didn't you say the judge retired before the video was released? She did. She did give notice of retirement before the video was released. And I went over it in the video. So how could she recuse herself because of a video posted by a defendant if she retired before she gave notice of the retirement? Jesus Christ. Why am I talking to Lyncher? You are just a terrible person, Lyncher, and I really despise you. The sequence of events is she gave notice that she was retiring, and then she recused herself from the case, and then she actually retired. Normally civilized people give notice of their retirement. They're like, hey, by the way, I'm retiring, and they give notice out to a certain extent so that the cases that are already set to hear, they can hear, and they're just not assigned new cases that are going to conflict with their retirement. You buffoon. How did Chili get so fat? I don't know. Did he get fat? I haven't been watching him. This sounds like the Chili and Deborah lawsuit. No grifting for $5,000 to have the body cam forensically analyzed. No equals now. Didn't we need an appearance from the dogs? Merb, come on. No. Where are the cocks? Well, they're around. They're just not here. Please help with my case 40%. I'll pay the 150 Pro Hack Vice. Clearly. Jesus H. Christ. Hey, Merb, I really appreciate your content. I'm 45 minutes behind, but it's good to see you. And it's good to see you too, Devin. Kansas City barbecue or Texas barbecue? Oof. I'm going to make people mad either way. They do this thing in Kansas City, Missouri, which is what I'm assuming you're talking about, not Kansas City, Kansas. Kansas City, Missouri, where they like, it's corn on the cob, but it comes out just all greasy. I don't know how. It's not like breaded and fried, but I think it's fried, and it is amazing. Texas for brisket, though. Kansas City, Missouri for pork, for ribs especially. Okay. How come Chili only sleeps with guys named Charlie? Is that Brett? I hear it in the background. There's something underneath. I'm on like a little piece of decking, and there's something underneath there, and Siobhan is desperate to get whatever's underneath it. What is the highest blood alcohol content ever? I don't know. Herb is blowing himself again. It's Siobhan. She's snuffling after something that's under the deck, trying to get it. I think it's a rabbit. I think the record blood alcohol content is 1.6. Sorry if you covered this already, but Utah is a one-party state. Well, there you go. I didn't look it up, so that's good to know. So that's probably why they didn't allege that it was an unlawful recording. Hit the like button. You could be right. I can't find the story. Might be 1.6. Like buttons have cooties. They do. Apparently, say the truth out loud. Upset nerve. Anyone resorts to a YouTube channel to swing their attorney dick has something to prove. Yeah, I'm here to swing my attorney dick. You're a loser. All right. Anyway, thanks for watching. Have a great morning.